Hello, everyone, and welcome to our topics webinar, Migration and Human Rights in the Age of Global Compact. I will start by presenting MDPI, and this company is a pioneer in scholarly open access publishing and has supported academic communities since 1996. It's based in Basel in Switzerland and has the mission to foster open scientific exchange in all forms across all disciplines. We currently have 473 diverse and open access journals, 464 of which are peer-reviewed journals and 9 conference journals, and they are supported by more than 295,000 academic experts who share our mission, values, and commitment to providing high-quality services for our authors. When it comes to topics, topics are collections of papers that concentrates on specific multidisciplinary topics in 2 or more related MDPI journals. Topics allow authors from different research areas to unite around one theme and describe multidisciplinary applications and develop new ideas. We have 5 different journals that are involved in these in this topic. So I'm gonna present each one of them. First one is Societies. Societies is an interdisciplinary journal that brings together different scientific approaches to engage with societal questions to enhance our understanding of the social realm throughout history. This journal publishes original empiric research papers, literature reviews, and conceptual papers. Our aim is to publish papers that are of significant impact on addressing present and emerging societal questions. Of course, you have on your screen the topics that are suitable for this journal. Next one is Laws. Laws is open access journals featuring scholarly work which examines critical developments in substance and process of law and legal systems around the world. Laws encourages legal academics and criminologists to publish their empirical, doctrinal, and or theoretical research in as much detail as possible. Contributions that bridge traditional boundaries and challenge injustice are particularly welcome. Social Sciences is international peer-reviewed, quick-referring open access journals published once a month by MDPI. And this journal seeks to appeal to interdisciplinary audience and authorship, which focuses upon real-world research. It attracts papers from wide range of fields, including anthropology, criminology, geography, history, political science, physiology, social policy, social works, sociology, and more. And there are some of the topics welcomed on the screen. Then we have World. World is also multidisciplinary and open access journals devoted to past, present, and future links between economic, political, social, and environmental issues. It provides an advanced forum for engaging with local, regional, national and international trends, challenges, conflicts, and opportunities relating to sustainability, adaptation, and the Fourth Industrial Revolution. It publishes original research articles, reviews, and communications, as well as special issues, of course. And the last one is Climate. It is international and open access journal on climate research at all scales. Our aim is to encourage scientists to publish high-quality research as quick and much detail as possible. So our program for today is, I would say, not that long, but very nicely written and developed. So we are hoping you will have quite a lot of questions in the end. We will have Q&A session in the end after all the presentations, and we welcome you to leave all of your questions and just name the person you are asking questions, so we can have a response for you later. Relevant topic connected to this webinar is migration and human rights in the age of global compacts. And our chairs are actually guest editors. Deadline for manuscript submission is, or actually abstract submission is 31st of August, and the end of October is for manuscript submissions. So as I mentioned, in the screen, you can see Q&A box, and this is where you can leave your questions. So I will present our chair, Professor Dr. Kielt, and I must say that she has quite a biography. So she is a global chair in social justice at University of Liverpool and is emerita professor at Radboud University in Netherlands and legal counsel for the London-based law firm. So she is working quite a lot and has quite a big biography that is available in our website. So I would like to share the floor with her. I will stop my presentation and ask our chair to join us and present all the speakers.
Thank you so much, Tatiana, and welcome to everyone. It's a pleasure to be running this second webinar on migration, human rights, and the global compacts. I'm going to introduce my speakers in a minute, but first I just want to give a little bit of background to where we are in respect of the global compacts. Certainly, migration is on the front page of newspapers around the world almost every day at the moment, and in almost all circumstances, considering developments, particularly in one part of North America. The issue of migration is very much intertwined with the question of the human rights of persons who have moved to a country other than that of which they are citizens, and what is happening to them. The question of the age of the global compacts comes in particular in the adoption of two compacts, a fairly new term in the lexicography of the United Nations, adopted by the General Assembly at the end of 2018. And they are both the Global Compact for Refugees and the Global Compact for Safe, Orderly, and Regular Migration. Both are based on international human rights law and expressly indicate that their provisions are the agreement of the international community as to how human rights apply in respect of persons who are moving from one country to another, who are living in a country other than that of their citizenship, or who are in need of international protection. It was a seminal moment in 2018. Many of us, all of your speakers here, were very much engaged with the negotiations, providing advice to the international institutions and the negotiators as to the content of the compacts and how best that content should reflect the human rights of migrants. We indeed published a book for the negotiators and for the world on the human rights of migrants in the 21st century for that purpose. The implementation of the two compacts has now been underway for almost 8 years. And we are going to hear how the international institutions have sought to achieve an effective implementation of the compacts. This will also come up in all of the presentations regarding different parts of the world. Where have the compacts been embraced by the national authorities of different countries, and where have they had very little impact? There are three main foundations on which the Global Compact for Safe, Orderly, and Regular Migration is founded. And those are, first of all, international human rights law, a body of law which has been established by the international community, conventions which have been signed and ratified by states, and incorporated into their national law in accordance with their constitutional traditions. It is a settled body of law which is continuing to expand. You may have been following the discussions on the environment which have been taking place over the last weeks, particularly in respect of the sea. The second principle is non-regression, a new principle in human rights law. It started in particular in the field of employment law, at least in the European perspective, but reached the international community in the context of environmental law. And the principle is that the position at the moment of the adoption of the compacts in 2018 should be a baseline in respect of which states should improve the treatment of people on the move subsequently. Sadly, we have seen many parts of the world where this principle of non-regression has not been applied in good faith by states which have adopted and which voted for the global compacts in the General Assembly. The third principle on which the compacts are based is non-discrimination. And here, the principle of non-discrimination in respect of differential treatment on the basis of nationality is intended to be the object of the need for a justification. And this also has the objective of bringing the rights of persons on the move closer to those of citizens, and the differential treatment by states requires a justification, and a justification which must be necessary and proportionate to the differential treatment which is being applied. We will come back to these principles in due course. The question that we are going to address now is, how do we see the implementation of the two compacts, particularly starting with the one which is perhaps the most urgent in recent times, which is the Global Compact for Refugees? What is happening in terms of those people who need international protection and where should they be receiving it, but also the Global Compact for Safe, Orderly, and Regular Migration. I will introduce my speakers now. Each speaker will have 20 minutes to present, and we have quite a few slides. But just before I introduce my speakers, I want to introduce my co-editor of the special theme of the Global Compacts, Professor James Simeon, who is a professor in the School of Public Policy and Administration at the former head of McLaughlin College at York University in Toronto, Canada. He has also been acting director of the Centre for Refugee Rights there. And we have been working together over the last few years to enlarge the knowledge base about the compacts through our work with MPDI. Our first speaker is Dr. Madeleine Garlick. She is Chief of Protection Policy and Legal Advice Section in the Division of International Protection at the United Nations High Commissioner for Refugees in Geneva. She was also in 2018 Assistant Representative for Protection at UNHCR in Iraq, and also responsible earlier in her career for UNHCR's liaison with the EU institutions. Our third speaker, our second speaker, but the third person I'm presenting is Professor François Crépeau, who is well known to all of you. He is the Hansen-Tamer Oppenheimer Chair in Public International Law and Director of the McGill Center for Human Rights at McGill University, Montreal, Canada. He was the UN Special Rapporteur on the Human Rights of Migrants from 2011 to 2017, and so is someone who was very much engaged in setting the framework in which the compacts came into existence. Our last speaker is Adrian Barry, King's Counsel, who is a specialist in immigration law in respect of global migration, citizenship, and settlement. He's based in the UK. His specialism is UK immigration law, British nationality law, and EU-UK mobility. He also works on human rights, statelessness, and asylum, and is a professional author and consultant. So I'll start now by asking Madeleine to take the floor. Madeleine, I think you are going to share some slides. Is that correct?
I'll do without slides if that's okay, Elspeth.
Excellent.
But I'm really very honoured and delighted to have the opportunity to be with everybody here today and to be part of such a distinguished panel. And I'd like to begin by recalling some of the key guiding principles that were articulated in the Global Compact on Refugees. And its paragraph 5 is particularly relevant in this regard, stating that the Global Compact emanates from fundamental principles of humanity and international solidarity and seeks to operationalize the principles of burden and responsibility sharing to better protect and assist refugees and support host countries and communities. The Global Compact is entirely non-political in nature, including in its implementation, and is in line with the purposes and principles of the Charter of the United Nations. It is grounded in the international refugee protection regime, centered on the cardinal principle of non-refoulement, and at the core of which is the 1951 Convention and its 1967 Protocol. I think it's very timely for us to go back to those founding principles, nearly 7 years on from the affirmation of the Global Compact by the UN General Assembly, because the international community in many ways finds itself as a pivotal moment for refugee protection. And I think it's important in forums such as these that we ask ourselves, what do these words mean and what needs to be done to ensure that they can be reflected in practice and in the actions of the states that have committed to them. Very important progress has been made in the making and fulfillment of pledges, in particular, to advance the Global Compact objectives, both at and since the 2 Global Refugee Forum that were held in 2019 and 2023. And UNHCR's website details the vast number of over 2,000 pledges in the 2 global fora and the crucial importance of the impacts that they have had in achieving improvements in conditions, in achieving access to services and cooperation arrangements with the help of many stakeholders who have made those over the course of time. But arguably over recent months, and in particular since the beginning of 2025, we've seen some particularly serious developments that arguably move in the opposite direction of the principles that are articulated in the Global Compact, and particularly away from responsibility sharing and cooperation towards unilateral and more inward-looking policies and approaches. In just over 1 week, it'll be World Refugee Day, and UNHCR will be issuing its annual Global Trends Statistical Overview, which will record that over 129 million people worldwide are forcibly displaced or stateless or otherwise in need of UNHCR's assistance. As has been the case over many years now, the vast majority of those people, over 2/3, are in low and middle income countries, including many countries close to or neighboring countries of origin of refugees. and close to 1/3 in what are referred to sometimes as the least developed countries. And what we've seen at the same time as these numbers have climbed to that level has been a number of steps which have led to the reduction in financial contributions to humanitarian assistance and to refugee protection by some key donors worldwide. And in the most visible of these, the US, at the end of January 2025, announced firstly a freeze of funding that was already committed for 2025 to a number of UN agencies and other humanitarian actors. And secondly, a comprehensive review of its longer-term cooperation with various partners, including, amongst other things, to assess whether or not their activities are making the US safer, are aligned with its values, and are encouraging its development in a more prosperous direction. On the first of those decisions, we've had a number of programs whose funding was frozen that has been freed up across the UN system. On the second, the outcome of this review of relationships and cooperation that will be pivotal to determine the levels of support to activities in the longer term is still to be concluded. It's impacted very many organizations, but UNHCR is amongst those who has been particularly affected, with some 42% of its budget previously contributed by the US. Clearly, the financial impact of this has been very far-reaching. The UN, including UNHCR, has turned to other donors in the face of this development, seeking to encourage them to advance or to increase their contributions, or both. But we've also seen a number of other important donors who have announced their intention to reduce their contributions to humanitarian assistance worldwide, including the UK, including Germany, including Netherlands. Some have chosen to advance or to increase their contributions, but it's not going to fill the gap that's been left. So as a result of this, UNHCR and a number of other actors in the international community have had to make wide-ranging staffing and activity cuts. With UNHCR, it's a very significant proportion of our workforce that's going to be affected, and our presence on the ground in a number of countries where we've had operations for many years will be significantly scaled back, and in many cases will end. UNHCR has sought to make clear its intention to continue to focus on core mandate areas of protection and solutions, but there's no question that this is also going to be affected in many ways. And in recent weeks, we've sought to be frank with donors, with the press, with the international community, with countries that are hosting large numbers of refugees about what this might mean, underscoring that we believe we're going to see more refugees are facing greater risks of poverty, of abuse, of being forced to return home, to face danger, or the prospects of having to move onwards to seek the means of survival and safety. What we've seen is that chronic underfunding, which was already an issue in many less visible crises worldwide, including in the responses for refugees from Sudan, South Sudan, Myanmar, and the Democratic Republic of the Congo, are facing even more significant financial pressure. And programs in key areas, including protection of women and girls, protection of refugee children, are going to suffer as a result of that. If I could choose the area specifically of protection for women and girls, including against violence, we are going to be announcing in the Note on International Protection, which will be coming out in the next couple of months, that programs which have very successfully addressed gender-based violence, including prevention as well as support for survivors and victims, are going to need to be cut back very significantly in countries including in the West and Central Africa, as well as the Eastern Horn. In South Sudan alone, some 80,000 women and girls at risk of violence are going to have reduced access to medical care, legal assistance, and economic support. The impacts on refugee children are also, we fear, going to be extremely serious. We've documented approximately 17.4 million refugee children who are at risk of violence, exploitation, trafficking, or separation from their families. And numerous dedicated programs for child protection that UNHCR has implemented worldwide until now are going to face significant reductions. So what's the UN going to do about all of this? Well, firstly, we need to be looking harder than ever at ways to improve efficiency, and there's no question that the UN can and needs to be more efficient in the way in which it works. Duplication needs to be eliminated, unnecessary competition amongst UN actors, better division of labour. And there are important processes going on that are led by the UN Secretariat, including the Humanitarian Reset, that's focusing on coordination, including in the context of responses to internal displacement. And there is also the UN 80 process announced by the Secretary General, which includes review of a number of important mandates that were previously, or that have been exercised by UN and related actors over recent years and decades. And that means that a number of special procedure mandate holders, peacekeeping missions, and other mandates awarded by the General Assembly will be reviewed. And some people have asked, does that mean UNHCR's mandate is going to be reviewed? Certainly, UNHCR is committed to and is part of these processes and looking at ways in which we can improve what we are doing. But as an organization with an international legal mandate that forms part of a binding treaty, it's a more complex process to envisage that UNHCR's mandate would be negotiated. And we've also had overwhelming expressions of support, which will be formalized in the context of UNHCR's executive committee in the coming months, urging us to continue to try and do our mandate work under challenging conditions. Some people are asking about UNHCR and IOM and about their relationship, a very important question also to consider when we look at the two compacts and their complementarities and coordination. Some people ask, do we need both organizations? I think from the point of view of both organizations, we definitely see scope to improve our cooperation and coordination, to look at where we can provide better leadership working together in mixed movement situations, and looking at some circumstances where one of us may have a presence on the ground that's stronger than the other, and where leadership should be held by the one that is in the strongest position. But the two organizations nonetheless feel that there is more than enough work for each in their respective areas of activity. In IOM's case, working, amongst other things, to protect the human rights of migrants, including pursuant to the objectives of the Global Compact on safe, orderly, and regular migration. And in UNHCR's case, seeking to ensure protection for refugees and solutions to their plight. These phenomena are not going away. And the clear lines of action that the Compact set out provide important and urgent tasks for us in this environment, which are more important than ever. And so that really brings me to the question then, what does all of this mean then for the Global Compact on refugees? And from our viewpoint, I think I have to say that efforts to ensure that we can continue to pursue its goals are more important than ever. And I want to focus on a few elements in particular. Firstly, the multi-stakeholder approach that's clearly reflected in the Global Compact on refugees. And this approach, of course, recognizes that it's not only states that need to be and are key actors in ensuring access to protection and respect for rights for refugees. On the contrary, what we know is that there are many non-state actors, including civil society organizations, refugee-led organizations, women-led organizations, academia, networks of many actors, private sector actors, and many others who can and do make important contributions to refugee protection and to progress towards solutions. And arguably, this is a moment when we need to be making sure that there is the space, the platforms, the visibility, and the opportunities for many non-state actors to be playing that role more effectively in line with the Global Compact and the commitments many have made to do so. This isn't to say that states should be absolved of their responsibilities under international law. On the contrary, but what we might need to see is more opportunities and a greater role and greater calls upon non-state actors to be reminding states of what their roles need to be pushing them to do their job, to be undertaking complementary action, and providing, importantly, opportunities as well for meaningful participation by people with lived experience of forced displacement in decisions affecting their lives. And this is a crucial part of the Global Compact where there is ample scope for more to be done in better ways. We've seen important progress over the last few years at the last Global Refugee Forum. Some 300 refugees were represented as official delegates, including as members of states' delegations, and had the opportunity to take the floor and to debate and to criticize the UN, amongst others, and tell us what we should be doing better. We need to have more of that. especially in the environment where we are operating now, where we are going to see very real impacts on the lives of people who are displaced themselves. A second key area of the compacts that is more critical than ever right now relates to responsibility sharing. And this means, amongst other things, seeking to look at ways in which more can be done to support countries that are hosting refugees in very significant numbers. We hear their concerns and their disgruntlement in very palpable ways in Geneva at the moment, as they speak in official fora of their grave concern about the potential consequences of funding cuts for their citizenry, for host communities, and for their ability to continue to host refugees in very large numbers. What's going to happen if they decide that they are no longer going to continue to host refugees on their territories, that they're going to emulate restrictive approaches and inward-looking approaches that we have seen in other parts of the world? One of the inevitable consequences of that would be more onward movement of refugees. If they're not able to find protection and access to the means of survival and timely solutions in the countries to which they're fled, they're going to feel compelled to move onwards. And we see this already in a number of important refugee situations around the world. So as part of responsibility sharing efforts, this means that states need to be encouraged to do more to cooperate, not with a view to restricting or to deterring movements, but rather ensuring effective access to protection, including development of capacity for protection at all points along journeys, but also ensuring particularly that people can find access, safe and legal routes to safety, including in global north countries where they need that. And that's the third area I want to highlight, if I may, Elspeth, the need for more support for solutions for refugees. The Global Compact laid out clearly the imperative of creating more conditions for voluntary return in safety and dignity for refugees. And we have some really important opportunities right now. With the situation in Syria changing dramatically over recent months, we have seen very significant numbers of returns, but conditions are not yet right for that to be stable or to be sustainable for millions of the refugees that want to go back. So we need caution, we need continued access to protection in host countries. We need people to be able to go and undertake visits to see what conditions are like, to prepare for return, but to retain the opportunity to have protection in the countries of asylum to which they have fled before doing so. We also see other opportunities in other parts of the world, including in parts of Central Africa and elsewhere. And this similarly needs to be part of what needs to be supported, but in a way that does not deny access to protection for those who continue to need it, or to force return prematurely. So really, I think what we see here are some key opportunities for access to protection and solutions to be reinforced, but it's going to be a matter of rallying the political will of states, being encouraged to recognize the long-term benefits for them of doing so, and of UNHCR seeking to find better ways to conduct its core mandate work, including through working to ensure legal standards are upheld and respected, working in new and different ways under today's conditions. So with that, many thanks, and I look forward to discussions and questions. Thank you.
Thank you very much, Madeleine. I think that was a very sobering presentation, to think that 42% of the budget of UNHCR was dependent on the United States, and the current administration's position is not particularly friendly. The consequences on the ground are going to be enormous. Thank you very much for a very interesting presentation in respect of the kinds of challenges you're looking at from an institutional perspective in the international community, to encourage and ensure that the principle of non-refoulement is indeed correctly carried out by all the signatories to the Refugee Convention. I'd now like to turn to our second speaker, Francois. I'll hand over to you. I think you're going to focus a bit more on the Migrant Compact.
I will, and I will start by sharing one slide, essentially, or two slides. Okay.
Perfect.
Sorry. Now I have a problem. Just 1 second, because I need to change something. How come I do this? How do I do this? Sorry, I need to see. I decided to have only one slide for everyone to see in order to not overburden. Here it is. Okay. Now I can do this. Okay, that's only one slide. That's good. That's what I wanted. Now, yes. Okay, good. The title of my presentation is Reducing Exploitation in Labor Markets to Help Facilitate Mobility. That's the point I'd like to make. And I'm talking about, as you mentioned, the Global Compact on Migration and what is the future of human mobility. You see the 4 points that I'm going to go through. Repression of mobility keeps failing. It keeps failing as a mechanism to prevent mobility, but it's not failing politically, and we'll come to that. Migrants' precarity is policy induced. And we'll see how that is important in terms of the economics of migration. Mobility facilitation is a new framework. That's the Global Compact. And where do we go from the Global Compact with probably decades to go before it is fully implemented? So my first point is that repression keeps failing. We have to understand that we are a migrating animal species. It's not the last 3,000, 4,000 years of settlements that are going to change that. We move all the time for all sorts of purposes. There is a constant of 3.5% of the world population that is on the move. It's a bit increasing in the past years, but it's around that. And demographers say that it's been, since they have statistics, it's been a constant. So mobility is not an anomaly, it's the rule. It's often generational. We may not see it as such, but when I ask the question to audiences, who lives today in the city of birth of their foregrandparents, I always have between 0 and 5% of people raising their hand. We are all descendants of migrants, not necessarily international migrants, but people who've moved. We have to remember that the biggest migration of the 20th century was rural exodus, people leaving the countryside to go to cities. From the 50s to the 70s, so post-war period, post-war reconstruction period, we had relative freedom of movement. If you Google the words Swedish girl, Indian boy, 1975, bicycle, you will have an extraordinary story of mobility across continents. It was possible. Millions of North Africans and Turks entered Europe to find work. Millions of Mexicans entered the US and went back and came back and went back and came back for all sorts of reasons. Mobility was the rule of the game. At the end of the 70s, because of the economic problems caused by the oil shocks of the 70s, high inflation, high unemployment, our politicians resorted to the easiest trick in the book, or the oldest trick in the book, which is to blame someone. And they said, we're going to stop low-wage migration, never high-wage migration, never the expats, who are not even called migrants, but we're going to stop low-wage migration in order to protect the jobs of our citizens. This attitude was based on stereotypes which did not connect with reality. First, migrants would continue to need to come. Second, employers would still continue to need them to come because no citizens will take the kind of jobs that migrants will take in the labor conditions that migrants will accept because they have no other choice. So since it did not connect to reality, it created immediately unintended consequences, and it was unintended at the beginning, I believe. There's no Machiavellic intention there. And so states established those mechanisms to fight undesired mobility, deterrence measures such as little access to work permits, to social protection, to legal aids, increased detention, but also containment mechanisms, visas slapped on any country that produced undocumented migrants or asylum seekers, carrier sanctions on airline companies, for example, interdiction mechanisms abroad, intelligence sharing with other countries, externalization, which has been discussed quite extensively, considering what Europe is trying to do in Africa, West Africa in particular. And migration was included in the global security paradigm. Migration has become a security issue when historically it was an economic and social issue. And this, attempt at preventing undesired migration mostly failed because it diverts movements rather than eliminate them. And we have to understand that hope is the engine of mobility, and hope is wired into the human nature, into our DNA. We move because we hope it's going to be better elsewhere. We have to understand the low-wage migration dynamics. We talk a lot about push factors, violence, survival migration, which violence for refugees, and deprivation for those who call economic migrants. If you can't feed your family or can't educate your children or pay the health bills of your parents, you are going to try to find something better elsewhere. The hope to create a better future is the key here. But we never talk about the pull factors. And the pull factors is the fact that, for example, refugees are looking for protection that they can't find in their own country or even in the neighboring countries, but also the labor needs, often unacknowledged, that many countries, not simply the global north, because what is true for the global north is also true for Malaysia, for South Africa, for Brazil. And we have labor needs often unacknowledged and often in non-delocalizable industries. And even though it was not Machiavellic at the beginning, the prohibition of movement across borders has triggered undocumented mobility, has created precarity for these undocumented migrants, and more recently, temporary migrant worker who come under programs that recreate this precarity. And this precarity is policy induced for a purpose. That's my second point. Migrants come for the vast majority, including refugees, when it's a second movement, after having escaped the violence of the country of origin, they try to find a place where they can rebuild their lives. And so migrants come because of labor markets. They want to have a job, they want to earn money, they want to be able to pay for healthcare, schooling, ordinary life, and create a good environment for their children. What happened after we stopped undocumented migration around the end of the 70s, beginning of the 80s, we have to understand, for example, that the expression asylum seeker appears in 1981 in the media. It did not exist before. It appears in 1981 because it is the consequence of stopping low-wage mobility. Those who needed protection before the end of the 70s came, asked for a work permit, a residence permit, and obtained them, and did not need to ask for refugee status. Same thing for migrants. They came, they did not need any particular smuggling mechanism to come. They could come. And so stopping migration at the end of the 70s, beginning of the 80s, created immediately two crises: the asylum crisis first, and then the undocumented crisis a few years later. For example, the number of asylum claims in Canada in 1976 were 600, and in 1986, 10 years later, were 60,000. And so in between, somewhere around 81 comes 1980, actually, for Canada, comes the restriction on low-wage migration. So this precarity that happens because they are coming undocumented or they are in temporary migrant worker programs that recreate that precarity, for example, by being tied to a single employer, has created cheap labor for businesses. Because they're in precarity, they can be exploited. and they're exploited in non-delocalizable sectors of the economy with low profit margins. That's agriculture, care, construction, extraction, fisheries, hospitality, all these sectors that cannot be delocalized like manufacturing and have not much profit margins, so that they are trying to reduce labor costs constantly. This is very well known. It's been well known for 45 years, and there's almost no oversight. And we have to understand that that precarity rests on the combination of migration policies that are restrictive and labor policies where labor standards are simply not applied to undocumented migrants or temporary migrant workers. It creates dangerous employment relationships. The precarity of status creates a fear of being arrested, detained, deported, which means a life in the margin, and which means that you cannot protest, contest, go to court. You cannot speak up about the exploitation. You cannot defend your rights because other people hold your life course into their hands and your family's life course into their hands. Migrants have very few options. Migrants' precarity is policy induced, and it has become, I don't think it was initially, but it has become a strategy to reduce labor costs, and no one does anything about it. No one does anything about it because there is no political will to change the system. If you changed the labor conditions of migrants, if migrants were empowered to contest, protest, unionize, go to court, that would considerably raise the labor costs for many of those sectors of the economy, which would create, bankruptcies on the one hand, but for the businesses that will survive, they will have to increase the cost of the products and services that they produce. And that would create inflation. And in both cases, you would anger employers, entrepreneurs, and you would anger consumers for the benefit of people who are not voters. So in electoral democracies, what prompts politicians to act is the will of the voters. If they sense that the mood is changing, they change their tune. You're not going as a politician, and I'm not blaming them individually, because that's the thrust of the system, of the political system we have, which is the best system we've ever invented to govern ourselves. But the thrust of the system is that if you're not represented, you don't count. And politicians, governments, not politicians individually, but governments, will not favor people who do not vote while angering people who do vote. So we have today mechanisms put in place to block migration while allowing enough migrants to come in order to fill those undocumented migrant, labor markets. And we have created temporary migrant worker programs with single employer status very often, which recreate also some kind of precarity. And that keeps migrants in the margin, prevents them from speaking up. Unionization is discouraged or prohibited, etc. And increasing labor costs will be politically difficult. So we have an economic benefit, an economic obstacle. We don't want to increase labor costs. And we have a political obstacle, is that migrants not voting means they don't count in the political debates. And we see that in the fact that actually politicians can say, many of them choose not to, but many politicians do, can say whatever goes through their minds about migrants. One can say that, all Mexicans are rapists and drug dealers. And that doesn't create any pushback in the electorate, really. People even win elections with that. There is no political responsibility really for what is said about migrants, because that is not the experience of the voters. Most of the voters do not have the migrant experience. So the electoral discourse is often, very often, based on myths, stereotypes, fantasies, they create unemployment, they create crime, they take their job. You take your job, they will bring illnesses, they bring insecurity, they bring their, for refugees, they will bring the violence of their country to here. They're responsible for housing crisis or for whatever other public service crisis. And we have, because of the global security paradigm, we have introduced an administrative law, which is the law of immigration. It's administrative law. We have introduced criminal language, criminal standards, criminal institutions without the guarantees that criminal law provides, the procedural and evidentiary guarantees that criminal law provides. And that is a huge issue. As long as the voice of migrants will not be heard, it will be difficult, very difficult. Women, indigenous peoples, the LGBT community know how difficult it is to have their voice heard, and they have the right to vote. Migrants don't have the right to vote. So it's interesting to see that in 2018, 152 states of the UN General Assembly adopted the Global Compact. In the question period, we can discuss why it is that they did such a bold move, considering what is the state of their own migration policies. It was prefaced by the Sustainable Development Agenda of 2015, where there was a concerted effort to bring into the agenda, into the goals, the Sustainable Development Goals, a measure of protection for migrants as well as for other minoritized groups, by adding in many of the goals, for all. So, for example, I take goal number 3, ensure healthy lives and promote well-being for all, at all ages. That for all meant that states committed to not distinguishing migrants or minorities or women from the rest of the population, from the majority or from the men. And that for all is in several of the goals. The Global Compact has developed that. It was negotiated and approved by states. It's not the wet dream of a mad professor. It's negotiated and approved by states, 152 states. Why it's that, we can discuss in the Q&A. I have my opinion on that. The central recommendation is that states need to facilitate mobility. The words facilitate, facilitation are used 62 times in the Global Compact. And this is going to be our greatest challenge in the coming years, how to facilitate mobility. And if we go through the objectives of the Global Compact, we see that their repression will still be needed because many states insisted on that. So repression of smuggling, trafficking in persons, managing borders in a secure and coordinated manner. All this is in the Global Compact. But most commitments aim at reducing repression against migrants and facilitating mobility. So for example, commitment number 5, objective number 5, enhance availability and flexibility of pathways for regular migration. This had been said by many international organizations, civil society organizations, lawyers, activists, professors, long before. But states have committed to actually increasing the number of visas or creating visa-free mechanisms for migration so that people would come without having to use smuggling rings. Still in Objective 5, facilitate family reunification. We've heard, I think, the German Chancellor recently saying that he wants to reduce family reunification. Objective 6, guarantee fair and ethical recruitment. The recruitment industry for low-wage migrant workers is a sick industry that thrives on exploiting migrants, selling them dreams, and not ensuring that these dreams are delivered to them. The same objective says that we should guarantee decent work. That's ILO lingo for apply labor law to migrants. Decent work means apply your labor code, which no country that I've visited actually does. In no country that I've visited labor inspections actually protect migrant workers that are exploited for lack of political will. Objective 7, facilitate regularization of status. You know how, for many countries, regularization, and certainly in the US, is called amnesty and is an absolute no-no for political reasons. It would mean, it would be interpreted by many as rewarding lawlessness. And indeed, in the English negotiated version of the Global Compact, in that objective, the word regularization has disappeared. It was there in the zero draft, but it disappeared in the final draft. In the French official translation, it has reappeared, which is quite extraordinary. But so we see how sensitive it is. In the same objective 7, include migrants in crisis preparedness. That's something which is very vividly illustrated by the Ukrainians in Europe. 1 million Syrians in 2015 created a major political crisis because nothing was prepared for them. And they came and they they overwhelmed the borders, and no one, someone had to say wir schaffen das, but they weren't prepared. The Europeans were not prepared. Since 2022, the European Union has welcomed 7 million Ukrainians, from what I understand. And there's no major political crisis. It's difficult. Public services are burdened by that. They have to cope, and many countries develop. But the European Union triggered the Temporary Protection Directive, which allowed those refugees to circulate through the EU, enter the labor market, go to school, and benefit from healthcare. And they spread through the EU. So mobility here prevented a major political crisis. Mobility allowed people to spread through different European societies. And that's, crisis preparedness. We should prepare for human mobility. Another one is Objective 15, and I read, ensure that all migrants, regardless of migration status, that's in the document, have safe access to basic services. Most countries do not give access to undocumented migrants to their public services, but states have committed to do that. And the last objective I'd like to mention is Objective 16, which says foster inclusive and cohesive societies by empowering migrants. And this empowerment of migrants is the opposite of what states have been doing for the past 45 years by disempowering them, by putting them in precarious legal status and social situations. And so to me, this shows the way forward if we want to de-escalate this war on migrants, which is a big hypocrisy because we still need them. We need to allow them to come and go, as was the case, but in a different form, but as was the case in the 50s, 60s, and 70s, when this was not a huge political problem. So what's the way forward? Well, in order to do that, we will need to do a number of things. First, we need to prepare for the challenges of climate change-induced migration. There will not be a legal status of the climate migrants, so we need to find technical solutions for various situations that are geographically situated. What Kiribati needs is not what the Amazon basin needs. We have different mechanisms to be put in place. So we need to respond creatively to different climate change-induced migration situations. Then we need more international cooperation. No country can facilitate mobility alone, because that will attract a more important number of migrants, and this will create political upheavals. So we need common approaches. We need to avoid crises and emergency preparedness. Common emergency preparedness will be essential. Common communication strategies, common development cooperation, mobility facilitation mechanisms. We also need, and that may be the most important thing at present, strategic planning of mobility. Migration policies are reactive to current events. My country, Canada, is probably one of the best countries in the world in strategic planning of migration by planning permanent residence for 3 years. When you look at all other governance sectors, be it infrastructure, energy, transport, healthcare, education, urbanization, they are planned for the next 10, 20, 30, 50 years in order to be able to plan the expenses needed and the timeline, etc. And they are constantly updated depending on other policies. Migration policies are often divorced from all the other policies. They react to current events. A kid dies on a beach, we need to change the law. Too many people enter the border at this point, we need to change the law. That's what creates the changes in immigration law. It's not planned. And certainly when we see in North America that migrants are blamed for the housing crisis, for example, well, the housing crisis comes from, first of all, lack of strategic planning of housing policies and lack of strategic planning and coordination with migration policies. And so we need, in order to have sustainable development of our societies, we need inclusive, integrated, resilient, transversal policies that work together and where all actors, all departments, not only Home Affairs or Immigration Department, have a say, including the voices of the migrants. And that will be an element, a key element in my conclusion. We need to aim at fluid border crossings. We need to make mobility easier, safer, cheaper, faster for the migrants themselves, but for societies. We need to allow people to come and look for work in regulated labor markets. And when I say regulated, I mean with labor inspections for everyone. We need more free movement zones like the EU, like what the AU and ECOWAS are trying to do, and SADC is trying to do, like Mercosur has been doing for several decades. We need more of that, and we need to expand them. For example, I don't understand why there's no freedom of movement in North America. There could be relative freedom of movement over time, and we can plan this for 10, 20 years. There could be, aiming at freedom of movement between Canada and the EU. These things can take time, but we can plan them over the long term if we want to plan them over the long term. We need to switch from a zero tolerance policy to a harm reduction policy. We've done that for alcohol, for drugs in many countries. In Quebec, we now have a public government society that sells cannabis and has taken 70% of the market. So we know from the prohibition era, from this recent experience, that the more you prohibit, the more you create underground criminal activities. We are currently subsidizing criminal networks that prey on the precarity of migrants. Exploitative employers, recruiters, moneylenders, lodgers, all those are preying on migrants, and migrants do not have the capacity to speak up. So we will need to empower migrants to speak up, recognizing their agency and recognizing their mobility as a key factor in our development. That would reduce the pressure on refugee determination systems, because many refugees would ask for a work permit, not for refugee status, which is very cumbersome. This would reduce the power of criminal networks. Prohibition breeds crime. This would enhance the capacity to control border crossings, because people would go to the border guard and not try to go underground. It would increase also the capacity of migrants to integrate, and it would free resources. And we could invest that in integration and in other elements of development. So developing a culture of human security for everyone, including migrants, is key. And for that, we need to hear the voice of migrants. Unfortunately, the civil society organizations, the international organizations, and the lawyers that are, listening to migrants on a daily basis, pushing for change, are, have a very small impact. We need bigger players. And I think that one of the players that will be key in the coming years, if we can get them to move, are unions. I think unions at International Union Federation and National Union Federation, usually they agree with the idea of protecting migrant workers, undocumented migrant workers and temporary migrant workers. At local level, very often the unions are much more wary. They still see them as competition for their members. I think unions are starting to realize that these migrants are their future members, due-paying members, and will, in the coming years, coming decade, start representing them. And I think that the fact that those migrants are in the exact same position as industrial workers of the 19th century when facing the employer is a good reason for unions to take up that representation and allow migrants to organize and to collectively bargain. For that, we need also political will, and that is going to be difficult. But we have certainly our work cut out for the coming decades. Thank you.
Thank you very much, Francois, for a magisterial overview of where we are on the GCM and what needs to be done. In terms of the visibility of undocumented migrants, I think we're all a bit surprised that Los Angeles appears to be burning. Visibility perhaps takes place in a number of ways when oppression becomes unbearable. Let us turn now to our last speaker, Adrienne Berry, Casey. Francois, you've suggested that the lawyers who struggle for the rights of migrants have a small voice. I would say Adrienne has had a very, very large voice through all of the activities that you have been involved in, and I have known you for very many years. Can you take us to the rock face and tell us what we can expect?
Absolutely. Let me just share I want to talk to you about what use the Global Compact can be in strengthening international laws by which states are bound at this particular time. We have a short amount of time, but what I want to do is to show you in the context of using the UK as an example, not simply what substantive difference that using the Global Compact might make in the UK in order to try and influence government policy, but to show you how to approach the issue in any state jurisdiction. So I'm just using the UK as a kind of lab test. I'm not using it just talking to you as a story, but the story I want to tell you it is about the relationship, if you like, between international law and soft law and guidance and state power, and what this means. When you take a document like the Global Compact, or two documents, and you look at the UK or any government, what are they going to do with it? You know, are they going to read it? And if so, how are they going to implement it? They've got lots of things on their desk. And so the Global Compacts, they don't exist in a vacuum, but they are shaped. They operate in a context where power is used by states against individuals and against communities. And so the power of the Global Compact lies in its ability to shape and condition the operation of state policy, and where the Global Compacts support international human rights obligations, which are embedded in treaties. The question of what respect for the rule of law requires isn't simply understanding what conditions the lawful authority under which power is exercised, but also how to respect the universal ethical standards which are embodied in these international legal instruments and embedded in the policy recommendations in the Global Compacts. And so there's a big job here. It's more complicated than lawyers think, particularly lawyers in practice, because it's hard work. And so the advantage of the reason I wanted to take the UK as an example isn't simply because I'm from there and it makes my life easier when preparing for this paper, but actually because there's a change of government in July 2024, and the new government has put forward what it intends to do in the world, and it regards irregular migration to the UK as a problem, up there as a sort of national security problem, up there with risks generated by the war in Ukraine, by the conflict in Gaza and Palestine in terms of the way it destabilizes freedom of navigation through the Red Sea, and by other conflicts. And so from the UK's perspective, it's an issue to be solved, irregular migration, but from the point of view of strategic objectives, not from the point of view of a previous government having signed the global compacts. And so the kind of real life, real world example of how this is situated matters, because the previous government, Conservative administration, they signed up to the global compacts, they issued a couple of reports about their compliance, then there was a general election, and since then, and a new regime, and since then, a potentially politically more progressive government is pursuing an agenda which is about strategic priorities unrelated to the global migration compact, not because they are less progressive than the previous government, but because they simply didn't sign it. They don't own it in some respects, and they are moving forward with the continuity from the previous government about other objectives. And they have a policy which is very interesting if you have an international relations background, which they call progressive realism. And what they mean by progressive realism is a kind of third way between pseudo-realism, as they call it, and romantic idealism. And what they're accusing us lawyers of is romantic idealism. That's the phrase which the UK Attorney General has used. So let's get rid of the pseudo-realists at the outset. These are the people that want to abandon all the constraints of international law. You might see them in the current US administration, in the Reform Party in the United Kingdom, in various political parties in European countries, and no doubt in Canada as well, although I'm less well versed in that jurisdiction. And they seek power, or they're in power, and they would throw international law out the window, including the global compact, if given half a chance. On the other side are us. We are the romantic idealists, potentially. We conceive of international law, in the words of the UK Attorney General, as the reign of moral principle, providing a complete answer to any question. You simply follow your moral principles and lambast anyone who doesn't comply with it. And the Attorney General says, to position yourself like that is to be a pious priest, confining yourself to the comfort of self-righteous declarations. And so is he talking about us? Is the university academic department or the barristers' chambers as much a hotbed of romantic idealism as the priest's rectory in his example? Can we escape that charge? Well, the interesting thing about the UK perspective and about progressive realism is you could take them at their word, as we'll see, and hold them to the standards which they're now advancing. So this wouldn't work for somebody who wants to abandon international law, but let's just take them at their word and see if the global compact can be fitted in to their agenda, and can that be used as a lobbying tool. And they say that they say four things about progressive realism. One, that there can't be a pick and mix approach to international law. And that secondly, that if the international law framework fails, and if multilateral institutions fail, who benefits? Well, obviously, the kind of people who have no respect for the rule of law. And it's the third and fourth ones which are particularly important. You can see them on the slide. Thirdly, international law is a key vehicle by which states can both pursue their strategic interests and at the same time give effect to the norms and values they hold dear. Now, that's important because in the context of state power, it's not simply about what do I want to do in this substantive policy area, but what do I want to see in the society of states around my country? What kind of ecosystem do you want? Particularly if you have a liberal democratic state, are those values opposed to the exercise of your strategic interests, or do they really form part of it? And as you can see there, the fourth observation is, in fact, these obligations are not onerous, but manifestly in national interests, because respect for the rule of law is not just about international human rights instruments, but about free trade agreements, about a whole range of international arrangements, which you rely on for the glue. So if you look at the Council of Europe regional system, it's not just about the European Convention on Human Rights, it's about that convention that no one ever reads, that helps you make telephone calls across Europe, or helps you do something else quite practical. You're signing up to an ecology of compliance with international law because it provides predictability, certainty, it embodies your values beyond your own jurisdictional territorial borders. And that's the importance of it. So you can take progressive realism and say, well, we're going to judge you. The UK is bound by certain international instruments, by certain regional instruments, all of which we're very familiar with, and I won't take you all through them because we don't need to do that in this group. But what you can see is that already, before they come to look at the implications of the Global Compact, the UK, like many other countries, has a whole suite of things which are intensely problematic in terms of looking at the objectives of the, particularly the Global Compact on migration, which obviously lists things in a much more detailed way than the Global Compact on refugees. And it has a visa regime. So if you're from a refugee producing country, you require a visa before you can travel, carries liability legislation, so that there's a penalty imposed if the airline lets someone board without that relevant visa. New crimes of arrival, simply for turning up, not for entering the country irregularly, but just for arriving on a boat in order to claim asylum, having made a dangerous journey. A crime of facilitation, if you're steering that boat, even if your family members are on board, and you're considered to be part of the problem, you're criminalized. And then in national law, particular definitions of refugee convention terms relating to persecution, the burden of proof, the particular social group in the UK context, and also a new innovation in admissibility regimes, where if you come from a designated safe country, your claim isn't even processed, you're simply designated for return. These are the things which the UK is pursuing under its own policy, whilst at the same time saying it's complying with the Global Compact. And the question is, how can the Global Compact be helpful in a real context, in a real state? What are you going to do with all of this stuff? How are you going to make it work? And there are a number of things which I suggest. One, that the policies don't uphold the standards of progressive realism. So the UK government, they've put out there in speech after speech, the Foreign Secretary, the Attorney General, we've got this new paradigm we've invented. We're not realists, we're not into interdependence, we were into progressive realism. It's a sort of third way, classic progressive party sort of centering itself approach to these things. So you have to show them that this is your standard, this is your yardstick, including the values of a liberal democratic society, and you're not living up to them. Even the things you continue from the previous government and the things which you are putting into practice now. You're deviating from international law commitments, such as those in the Refugee Convention, when you pass acts like the 2022 Nationality and Borders Act. You've accepted the third bullet point. It's important to be seen to be honoring your international commitments. So it's about showing that you're doing so, not just telling people that you're doing so. You need to be doing that. And then also to understand that these global compacts, they are not romantic idealist documents. And I'm going to just take you through very briefly what they say. They are pragmatic documents that can actually be squared with progressive realism in the UK context, and whatever philosophy that other governments tend to accentuate, because they're responsive to the needs of state acting in good faith. They assist in the setting of policies to uphold international law commitments. They recognize the reality of governments representing the societies over which they have lawful authority, and in particularly in the context of democratically elected governments, they understand that governments have a democratically accountable mandate, and so that they need to respond to that electorate. It's no good being the pious priest if you're going to be voted out of office and a bunch of people who pursue pseudo-realism take your place. You've got to find some way of squaring that circle. So the key takeaway is about the global compacts is that they're not contrary to the thrust of the strategic objectives of the UK government or any other liberal democratic state. There isn't a zero sum here where you set off strategic interests against ethical and legal standards. What you have is an understanding in the global compacts that policy is to be made in the real world of accountability of governments, democratic or otherwise, to the inhabitants over which they exercise lawful authority. That can be hard work, that you need to audit things and not take at face value simply the state party saying, well, or the state party is the wrong term in the context of the global compact, but a state which has signed up to it. We filed a report, so it sort of says this is what we're doing to comply with the global compact. If you read the one from 2024 from the UK, which I do not advise you to do, written by the previous government, it's about 11 pages of stuff, all very interesting and everything. But in fact, you could write a 50-page document exactly as to where they're falling woefully short of the standards in the global compact. And so, and if you look at what can be done, and I picked out objectives from the Migration Compact, which specifically relevant to the UK. There are ones which are obviously particularly important in the UK context because they deal with the ways in which the UK is currently not complying, and that's the thing which matters. So if you look at Objective 2, the UK could be much more focused on providing relevant assistance, whether it's in terms of development, humanitarian aid, supporting the UNHCR, or actually doing political work in the countries which are refugee-producing states. In the context of Objective 5, a temporary migration route which is realistic. I mean, the UK had, as Francois was saying in his presentation, so the needs of a 21st century service economy could be well serviced by temporary migration routes, and this is a sensitive issue, but it's one where economic migration could deal with the question of people claiming refugee status. So at least some of them could be addressed by that. Objective 7. The understanding that UK human rights compliance, showing rather than telling, it matters, and so therefore reception conditions in the UK, enacting crimes of arrival, crimes of facilitation, and so on and so forth, which these things are making it difficult for people to arrive, jeopardizing them when they're crossing the English Channel in the context of the UK, but in a small boat. All of these things there needs to be seen to be compliance with the rule of law if you want to go around preaching that you are a human rights promoting state, as the UK wishes to do. And that also takes care of Objective 8, as you can see on the list as well. And then you can see other objectives which are there, some of which have got slightly jumbled up on the slides. Apologies for that. But you can see that this question of in respect of smuggling, for example, what they say in the text under Objective 9, it says we further commit to ensure that migrants should not become liable to criminal prosecution for the fact of having been the object of smuggling. Well, that's a straight fail for the UK, no matter how many reports they file in terms of their compliance, because they have produced crimes of arrival. And in the context of Objective 11, regional cooperation, the UK needs to understand that regional cooperation is not about being liberal or being kind. It's about sharing responsibility for doing things. It may well end up with treating people in a dignified way, but that's consistent with its professed values as well. At the moment, you have a slightly autarkic approach to it, where even a bilateral treaty with France seems to be beyond them, rather than understanding that, in fact, the UK operates in a small region, and that its border in many senses is in the Mediterranean or on the border of eastern Poland as much as in the English Channel. And then strengthening Objective 12, strengthening predictability and certainty in migration. Appreciate that the answer I've given on the slide in parenthesis relates to protection, but the question which arises in the context of people making journeys is the UK doesn't know what sort of person it is until they turn up. And so the migration compact covers the scope of people who are traveling to the UK by irregular means, whether or not they claim protection. Just very, very briefly, the Global Compact on Refugees. From the point of view of states complying, it's harder to pick its way through. It's not a criticism of the people that drafted it. But the great thing about the Global Compact on Migration, if you're trying to ensure compliance, is it's got these objectives. It's got a little bit of text that tells you what it says. And then you can say to the UK or to any state government that signed up to it, well, you need to be doing this. It's very easy it's harder to do that with the Global Compact on Refugees. But again, similar themes emerge in terms of burden sharing, responsibility, a regional approach, identifying international protection needs, processing. The UK obviously operates an individual determination system rather than a group determination system, facilitating access to durable solutions and local integration. And there's currently what we call in our system a white paper, which is a series of proposals to prolong the period of time before which you can get citizenship. So again, that's a straight fail as well in terms of the Global Compact on refugees. So and so what I want to sort of say in a nutshell is this is quite hard work. You can see I'm barreling through it because of our time constraints, but taking those words in both of those global migration contexts, analyzing what the state does in question, showing them where they fall short, the key thing to persuade them is not to berate them like the pious priest. The key thing is to say, look, we understand you have, to use the words of the Attorney General, we understand that you have these strategic objectives, part of which is the promotion of your values and respect for the rule of law, part of which is a common flaw that people will be treated with dignity, and the right to dignity obviously is sort of emerging norm, perhaps a little bit above just the right not to be tortured or to suffer inhuman or degrading treatment, and to understand that the promotion of those values in the ecosystem within which your state works is consistent with building the platform on which that state operates. And in the context of a state like the United Kingdom or France or Canada, countries of that nature and type, these are things which can be made to work in harmony and can be sold as efficient effectively. And that's a word which human rights lawyers don't really use very often, but I'm going to use it in this context because it's the idea that this idea of strategic priorities and if you like liberal values can work in harmony, provided you do the hard work of working out what that means in practice. You can actually sell it. It's not a question simply of berating people. It can be sold in a democratic system to a government which is accountable to its electorate on a periodic electoral cycle, and that's what I want. But it's tough. I'm not saying it's not, but it can be done. And so that's my presentation. I'm conscious that we are possibly running out of time for questions, so I'm going to stop there. But you have all this. I'm happy for the slides to be shared after the talk to those who are on the list. Thank you very much.
Thank you very much, Adrian, and thank you for finishing on an upbeat point that yes, it's hard work, but it is possible as long as you have a government which is committed to respecting rule of law and international law in particular. And I think that was an excellent place to finish on. Yes, we're running out of time, but I think we can run a little bit over time. There's so much in each of the presentations we've had that I'd like to at least pick up some of the questions that have been put into the question and answer. And I think that the first question is really one to, I think, everybody, which is from one of our of the audience, who asks, race is implicitly embedded in migration policies in most countries in the global north. The main fear of migrants is that they are a national security threat, which is based on prejudice against migrants from the global south. How can the notion of population on the move be reconceptualized in view of the various crises of the 21st century? And I think that possibly that's a question that we should pose to Francois, because I think that it relates to the question, is 1 million Syrians the same order as 6 or 7 million Ukrainians? How do we go about transforming that? Do you want to say anything, or do any of my speakers want to have any comment? Francois, go ahead.
Yeah, I can say a few things. Yes, racism is part of it, absolutely. Now, racism is also fueled by the discourse of many politicians who believe that using the race card will raise their electoral prospects. It is no coincidence that the rise of Jean-Marie Le Pen coincides with the prohibition of low-wage migration. Jean-Marie Le Pen in 1979 said 1 million immigrants, 1 million unemployed. In 1981, he said 2 million immigrants, 2 million unemployed. And he won his first city in France in 1982. Now, here you have a racist discourse that points fingers at migrants, racist in the generic term, points fingers at migrants, saying they are responsible for all ills. And that's the beginning of a story which may bring Madame Le Pen or any members of her party to the French presidency. So the capacity of politicians to say whatever goes through their mind regarding migrants, depending on political interests, fuels the racist discourse. One thing that is interesting is that if, you know, in many countries, if you ask people, are there too many immigrants? The answer will be yes. You know, if you ask people on the street, yeah, yes, there are too many immigrants. And then you ask them, so Mohammed here needs to go back home. And they say, oh, no, no, not Mohammed. No, no, we know this guy. You know, his kids are in the same school as our kids. We like him. No, no, not him. It's all the others. And so that shows that as soon as you know someone, you change your attitude towards that migrant. Now, mind you, this is what happened for other minoritized groups in society. Women know very well the opposition to them getting the right to vote and all the obstacles they had to fight since then, including very recently, 75 years after the almost 75 years after the Universal Declaration, they had to fight, you know, sexual harassment. They know that, you know, it's difficult to change the attitudes. It's only when people realize, think about the LGBT community. It's only when people realize that that includes their family, this is part of who they are, that suddenly attitudes change. Migrants, it's very easy for politicians to say that migrants are the other, and the other is the problem. And that, to me, means that, yes, racism is part of the issue. But if there was a way of making, as it was just said, Adrian said, making politicians accountable for what they say. So one solution would be to give any person who lives in the country for 2 years the right to vote. Detach it from citizenship. Attach it to residency, as we've done for many other social rights. We attach it to residency, not to citizenship. We could, you know, I've even discussed with students, you know, other types of mechanisms. Why don't we give all migrants who reside in the country, the people who work in the country, why don't we give them half a vote? You know, some stupid idea that comes up. So they count in the public discourse. Many politicians win their elections by less than 2 or 3% of the vote, and so those half votes might count, and that would make a difference with citizens. So, I mean, there are all sorts of creative ways to make the voice of migrants count politically. At present, we have failed doing that.
Thank you very much. Madeline, can I hand over to you?
Thank you, Elspeth, and thank you to Raj for his question. And I think with regards to refugee protection, you know, race has a very important and clearly acknowledged role, because, of course, the refugee definition specifically acknowledges that persecution based on race is one of the key forms of persecution on which, against which international law affords protection. And it's the almost 150 states that have acceded to the convention that have recognized and acknowledged that such persecution is a crucial problem that needs to be addressed, and undertaken binding commitments to ensure that people have protection against that. There's also in Article 3 of the 1951 convention an explicit prohibition against discrimination among refugees in the application of the convention based on race, as well as a religion or country of origin. So very unequivocal provisions there that describe discrimination based on race as a breach of international law. As regards, you mentioned the distinction in the response of European countries to the arrival of Syrians compared to Ukrainians. And I think one important point to recall, in addition to the key point that was emphasized about the value of strategic responses and the way in which political will and investment significantly improved the nature of the Syrian refugee, the Ukrainian refugee response vis-a-vis the host community as well as the individuals. It's important nonetheless to recognize that there is a crucial role to be played by countries, neighboring countries and regions of origin of refugees. I think it's really crucial that we've seen, both in the case of the Syrian as well as the Ukrainian refugee response, that countries in the immediate vicinity have been prepared to let people in and afford them protection. But what the responsibility sharing principle underscores is that it's not sufficient to simply leave countries in neighboring regions alone with that. And that's why access to solutions needs to be facilitated through support to countries and through international cooperation. meaning, of course, that the resettlement and complementary pathways can play a crucial role in achieving solutions for refugees who are living in countries where that's not necessarily feasible, or where the demands on the neighbouring countries are too great to make it reasonable for them to be called upon to provide such solutions alone. I think in that regard also it's interesting, important to recall that we're seeing an interesting process now underway around Syrian refugees in Europe. We have, of course, many countries that are very keen to see Syrian refugees go back. But then you have countries like Germany, which have made it very clear that the 6,000 odd Syrian doctors that are employed throughout Germany and making major contributions to the health system there are welcome to stay. So I think in line with the point that Adrian has underscored, we see very clear examples, I think, of not only benefits that accrue to countries in honouring their obligations in terms of reflecting their values, but also their immediate economic and material interests. And as we see many countries in the global north with populations that are ageing and shrinking, this, I think, is going to become and needs to become an even more feature of the discussion around access to labour markets, as Francois has highlighted, that is very much in the interests of the global north to facilitate both for refugees and migrants. Thank you.
Thank you very much, and for the very important reminder of race as one of the 5 grounds to be a refugee in any event. I'm going to move to a question which is directly to you, Adrian, from Amy Ranhart. And she asks whether you foresee the current British government being able to improve the migration situation for both visa and asylum seekers, or will the influence of populism make this impossible? And there's a bit more of an explanation to the question in the Q&A, but I'll hand over to you to answer that.
Thank you. I'm going to answer it in a way that is sort of generally relevant, I think, and it's because it's about that tension between representative governments, which are accountable to their publics, and this question of what would you do in order to enhance the rights and the dignity of people who are traveling either forcibly or otherwise to the UK. And I think the first thing to understand about any government, particularly one which is democratically accountable, is they are accountable to their public, to their demos, and that what they are going to do is be responsive to that. So there are 2 things that one can do in that context. Firstly, you can do what I was saying, you can audit the global compacts and try and show the government and audit compliance with them, try and show them how they could live up to their own promises. But the second thing to do, obviously, is the kind of soft parade of influencing the debate, influencing the ideological discursive framework within which this kind of politics operates. And so that's very important, because the idea that everybody, every family reunion case has a settled person who wishes someone from abroad to join them, and this question of, it's British citizens who are affected. I'm not talking about protection, but just generally British citizens who are affected when a family member can't join them. There are economic needs. The UK birth rate is falling, and Brits just aren't reproducing fast enough to sustain things. Well, the answer lies in their own hands, perhaps, but also in the context of migration policy. And quite seriously, these things are there to be confronted. And I wouldn't be too po-faced about the idea of enlightened self-interest motivating democratic publics. You shouldn't always expect them to be upholding universal moral values as their top line. Enlightened self-interest, which might be perceived of as selfishness in some theological seminary, nonetheless has its role to play. If you can persuade people that these things are in their interests, then you're on your way. And that won't help everybody in all contexts, but it will make an enormous contribution along the way.
Thank you very much. We have a couple of questions still remaining, but I think they have mainly been covered in the presentations generally. And I know that we're in the process of running over increasingly. So what I'd like to do is now hand over to James, who's going to make some final comments here, and thank everybody who has been so kind as to put in questions. We've had such wonderful presentations from you. I'm sure that going back and re-listening to some of the presentations will answer any outstanding questions. Over to you, James.
Thank you very much, Elspeth. I'd like to start by thanking our three guest speakers for their insightful and detailed commentaries on the impact of the Global Compacts on migration and human rights since their adoption in 2018. And as you mentioned, Elspeth, some 8 years ago now. I'd like to thank Dr. Madeleine Garlick for her really emphasizing the importance of this financial crisis that UNHCR and other humanitarian agencies are going through and the challenges that that's creating. And also emphasizing that this is actually increasing the relevance of the global compacts. And these could be used to help shape the changes that will be coming in the future. And also, I'd like to thank Professor Francois Crapeau for his presentation as well, but also what really impressed me was the emphasis he placed on the pull factors with respect to actually being so important in terms of migration itself. And then drawing back on the global compacts as well, where he indicated that states need to facilitate mobility and the importance of mobility in terms of advancing human security. And I'd also like to thank Adrian Berry for his, shall I say, a pragmatic use of the global compacts by the legal community or advocates with respect to holding governments to account. And even though he indicated that this is really hard work, he provided us with a methodology that we could use to employ the global compacts in terms of advancing human rights generally, not only in the UK, but also in other countries. Thank you very much, Elspeth, for chairing our webinar today. I also have to give special thanks to MDPI for organizing the webinar and for CARFMS, the Canadian Association for Refugees and Forced Migration Studies, for co-sponsoring the webinar. And Tatiana, thank you very much for opening the webinar. As you're all aware, and what was mentioned at the outset, Professor Elspeth Guild and I are co-editing the MDPI Topic on migration and human rights in the age of the global compacts. We would like to welcome you to make a contribution to our topic. Please visit our MDPI Topic website for more information. But please keep in mind that we have two deadlines, as indicated before, August 31st for the abstract submissions and August 31st for the abstract submissions and October 31st for the manuscript submissions. And I'd like to also note that we've negotiated a waiver from the normal MDPI publication fee for all the papers that will be published under our topic. Thus far, we've actually published 2 articles under our topic, but we're hoping to receive a number of other manuscript submissions as well. So we very much hope that you'll be submitting your contribution to our topic. If you have any questions regarding the topic, please do not hesitate to contact either Professor Elspeth Guild or myself. Our emails are found on the topic website. Again, thank you to all for your participation in our webinar, and we look forward to receiving your abstracts and manuscript submissions before the deadline. And since this webinar has been recorded, there'll be an opportunity for those people who are not present to have a chance to actually listen to this fascinating presentation from our expert guest speakers. Thank you all.
And thank you again from MDPI side. Thank you all for sharing and speaking, and of course to all of our attendees for attending this webinar. Certificates will be available at your site profile. And for any questions or suggestions, please just contact us. We are happy to hear what you have to say. Thank you again all for being here today and attending this webinar. We hope to see you again soon, because I feel like this topic has quite a lot more to be contributed and talked about. So I believe we will have some more topics similar to this one. Thank you, and I wish you a pleasant.
Goodbye, everyone.
Thank you very much.
Bye.
Thank you.
Very much. Thank you.